Hello everyone, and welcome to the February 2023 episode of MI PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our February 2023 topics include a case law discussion. We will talk about the soon-to-be published opinion of Al-Hajjaj v. Hartford Accident Indemnity Insurance Company. It's important to note that Hartford was represented by Secret Wardle on this appeal. And then we will move on to the case of Whitney v. Wilcoxon, and this is an unpublished opinion from the Michigan Court of Appeals. Then last up, we will talk about the Michigan PIP basics, specifically MCL 500-3114 Section 3, which deals with the order of priority as to employees when they are involved in motor vehicle accidents and seeking PIP benefits. Now, moving on to Al-Hajjaj v. Hartford Insurance Company. Again, Hartford was represented by Secret Wardle. The most important takeaway from this case is that when an insurance policy is facilitated by an independent insurance agency or a broker, the independent insurance agency or broker is considered an agent of the insured rather than an agent of the insurer. The 2018 amendments to MCL 500-1201 did not alter this common law rule, but the amendments did address a narrow and specific situation where the consumer or the insured and the insurance agency insurer each have their own agent, and these two agents have thus in turn have a written contractual relationship with each other. A standard contract between an insurance company and an independent insurance agent does not mean that the agency owes its primary fiduciary duty to the carrier. I did want to give a brief background into this case. Of course, it's a first-party no-fault litigation, but it's centered around the issue of rescission. And as we all know, that years after the Supreme Court has confirmed Bazzi v. Centennial, that rescission is available to no-fault carriers only when it is equitable to do so, though. In this case, it seemed like a fairly simple rescission argument. The claimant here was the applicant, so the case did not involve an equitable balancing of the scales like in Bazzi and Pioneer. And the misrepresentation here was in the procurement of the policy, so the limitations on rescission described in the case of Williams v. Farm Bureau did not apply either. In the instant matter, there was no dispute that plaintiff's application for insurance incorrectly indicated that his company was a physical therapy office that did not transport patients, when in fact the company provided medical transportation services for patients. There was also no dispute that the misrepresentation was material and that Hartford would not have issued the policy if it had known the true nature of the business. Plaintiff here blamed everything on the insurance agent instead of himself making this material misrepresentation. By making or placing the blame on the insurance agent who sold him the policy, the plaintiff then imputed those actions onto Hartford. Here, Secret Wardle successfully moved for summary disposition of Hartford, arguing that plaintiff's unsupported position was contrary to the common law rule that when an insurance policy is facilitated by an independent insurance agent or broker, the independent insurance agent or broker is considered an agent of the insured rather than an agent of the insured, which is obviously important here because if the insurance broker is an agent of the insured, then it is still the insured's material misrepresentation. Here, the contract with Hartford authorized the agent to solicit, quote, and bind insurance, but the contract also materially limited the agency's authority while also recognizing that the agency had the right to select and place insurance policies with other insurers. Ultimately, plaintiff's arguments were disposed of, and the Court of Appeals did not read Hartford's contract with the agent as modifying the common law principle here. Moving on to the case of Whitney v. Wilcoxon. Again, this is an unpublished opinion via the Michigan Court of Appeals, which was issued December 15, 2022. Now, the big takeaway from this one is that the plain language of MCL 500-3135-2C requires that plaintiff operate his or her own vehicle at the time the injury occurs. This specific case demonstrates that This analysis has not changed. Defendants must show that plaintiff operated his own vehicle at the time the injury occurred. So that actual operation of the vehicle is important. Ultimately, the court here held that there was a question of fact as to whether plaintiff was operating the vehicle at the time of the injury, since the vehicle was motionless on the side of the road when it was hit. Another quick background here. Plaintiff claimed negligence, gross negligence, and motor vehicle ownership liability under MCL 257401 and requested damages for pain and suffering, mental anguish, and other losses. The plaintiff was driving on US 10 when his vehicle died, so he coasted to the side of the freeway and stayed in the disabled vehicle. Defendant, who was driving a semi-truck, lost control of the truck and hit plaintiff's disabled vehicle. Both vehicles did overturn, and plaintiff suffered numerous and significant injuries. Again, at issue in this case is MCL 500-3101, Section 1, which indicates that the owner or registrant of a motor vehicle accident required to be registered in this state shall maintain security for payment of benefits under personal protection insurance and property protection insurance as required, and residual liability insurance is only required to be in effect during the period the motor vehicle is driven or moved on a highway. The court here held that MCL 500-35352C is unambiguous, and that individuals injured while operating a motor vehicle that is both owned by them and uninsured is in violation of that statute, and therefore they are not entitled to recover damages. Overall, the plain language of MCL 500-3135-2C obligates the defendant to demonstrate that the plaintiff was operating his own vehicle at the time the injury occurred. Here, plaintiff himself conceded that he had no motor vehicle insurance at the time of the collision. Plaintiff argued that there was an issue of fact as to whether he was operating his vehicle at the time of the crash that caused his injury, because his vehicle, like I said earlier, was he coasted it to the side of the road and then remained in the disabled vehicle. So was he actually operating it at the time? So again, the vehicle was uninsured, but was it in operation at the time plaintiff was injured? Now, ultimately here, since the plaintiff did concede that he was uninsured at the time of the collision, defendant's motion for summary disposition would have been proper if defendant demonstrated that there was no question as to whether plaintiff was operating the vehicle at the time of the collision. Now, moving on to trending topics in PIP litigation. Here I just wanted to kind of touch on an issue that I'm seeing come up a lot lately, and it is the order of priority as to employees when they are involved in motor vehicle accidents while operating an employer's vehicle or while on the job. Under MCL 500-3114, Section 3, an employee, his or her spouse, or a relative of either domiciled in the same household who suffers accidentally bodily injury while an occupant of a motor vehicle owned or registered by the employer shall receive personal protection insurance benefits to which the employee is entitled from the insurer of the furnished vehicle. Now, I know that sounds like a mouthful, but here what it's essentially saying is the employee or the employee's spouse or a resident relative of the employee or a resident relative of the employee's spouse can claim PIP benefits that they are entitled to from the insurer of a furnished vehicle, employer furnished vehicle, that is. But there's also the issue that the vehicle must be owned or registered by the employer. And this side just generally talks about how generally a person must seek compensation from his or her own insurer prior to seeking it from anywhere else. But in the event that that injured person does not have a policy, the priority provisions of the No Fault Act determine which insurer provides PIP coverage. Now, like I said, I've seen this issue come up a lot lately, and typically I've been seeing it in trucking cases where a trucking company has a fleet of their own trucks that are, or not even a fleet, maybe one or two trucks that are insured by a specific insurer. And then they contract out their over-the-road trucking jobs to an independent contractor company. And that company provides another vehicle, and that vehicle of the independent contractor, that truck, should have been insured by the independent contractor's own insurance company. And then unfortunately, the plaintiff or the person will get into a car accident in this independent contractor furnished vehicle, and then there won't be any appropriate insurance, and so that person will then try to seek PIP benefits from the insurer of the owner of the company instead of the independent contractor. And then when you have this issue of the independent contractor versus employee, you must do the economic reality test to determine if the claimant is indeed an independent contractor or if the plaintiff is an employee. If that plaintiff is an employee, then they must receive PIP benefits from the employer of the insurer of the employer. But if that person is an independent contractor, then they must seek insurance from the insurer of the independent contracting company or the MACP, or even their own personal insurance. But a lot of times what I've seen is there is no personal insurance, and then that independent contracting company doesn't have insurance either. Even though there are contracts or lease agreements, as they like to call them, that indicate that they should have gotten their own insurance because the employer, the quote-unquote employer, will not provide it and only insures their own vehicles, not the independent contracted vehicles. So for purposes of MCL 500-3114 Section 3, whether an injured party was an employee is determined by applying the economic reality test, and that is from the case of Aldenac v. Harco. And by that test, there's several factors to be considered. A, control of the worker's duties. B, payment of wages. C, right to hire, fire, or discipline. And D, the performance of the duties as an integral part of the employer's business towards the accomplishment of a common goal. So when you have this issue and you're trying to figure out if this plaintiff or claimant should seek PIP benefits from the employer or the independent contractor or somewhere else, maybe not even the independent contractor, but you have to dig really deep into what they do for a living. So for trucking instances, you ask who provides the money for gas. How do you learn about the over-the-road trucking job? Did the independent contracting company give you the job, or did the actual employer, quote-unquote employer, give you the job? Did you have control over how you would complete the job? Were taxes taken out of your check? Or because you're an independent contractor, were you required to pay your own taxes? And a lot of times you'll see these factors weigh in. It's not an all-inclusive list, but it's important to try to figure out and get to the bottom of that. And here we go. That the Aldenac case also said that while we have routinely cited these 4 general factors, we have also recognized that no single factor is controlling, and indeed the list of factors is non-exclusive, and other factors may be considered as to each individual case requires. So basically the economic reality test looks to the totality of the circumstances surrounding the work performed. So you want to get as many facts as possible out in discovery that show that this plaintiff was actually an independent contractor and not an employee. And that is all I have for you guys today. Thank you for attending the February 2023 episode of My PIP Monthly. Please feel free to contact me if you have any questions. Thank you.